Welcome. We have two competitors here, including a competitor who's appeared in this competition for the first time, which is a very nice accomplishment. I've had 3 of the 4 as we go along. I want to tell you, this has been a very tough competition. The measure is how you feel about the competition, you feel about your role in it, and I think that everybody should be very happy. I want to thank Jennifer Long and people who worked closely with her to make this happen, our students. This was a student-born organization. It's a student-run organization. And worked hard at this. We appreciate you coming more than we can express. What we'd like to do is set our school up as a national school for the purpose of preparing for the competition. We've had people from as far as Lapland and Japan in attendance. And we've tried to assemble good judges, and I think we've succeeded. We hoped the competitors would come, and they did. So, without further ado, we have the identification of the parties, the council, and the issues they'll be addressing. And if you could give us some idea of the order.
Certainly, Honorable Trina. My name is Bree Coyle. This is my co-counsel, Mr. Murphy. We're representing the respondent in this matter, and the parties have stipulated to the issues I believe that we've presented you with a list of those issues.
Mr. President, if I may approach with the proposed order that the parties agree to.
You may. You better give it to me while I'm here. I may not be here very long. All right. Let's share this. We have the respondent main argument 7 minutes, claimant reply, respondent rebuttal 1 minute. Article 79 liability, claimant main argument, respondent reply, claimant rebuttal. Damages, claimant main argument, respondent reply, claimant rebuttal. Okay, for the claimant, who do we have?
Appearing for the claimant today, my name is Brandon Nagy, representing Mediterranean Elite Conference Services, and my co-counsel Kevin Blood. Together we will be representing the claimant.
From Arizona State University.
Very good. Go first.
That would be
Sun Devils.
Yeah.
Good afternoon, Honorable Tribunal. Thank you for being here today. First, I'd like to give a quick overview of the case for the respondent. This is a case about upholding fairness and the legitimacy of the proceedings. I will be discussing the issue of disqualification. Today, the respondent challenges the participation of Dr. Mercado on the legal team of the claimant. And I will be addressing 2 issues. The first is the inherent power of the tribunal to disqualify counsel, and secondly, why the relationship warrants disqualification under these circumstances. So first, this tribunal has inherent power stemming from its duty to preserve the legitimacy and fairness of the proceedings. I'd like to direct you to 2 governing laws that provide this inherent authority to preserve impartiality. First, we can look to the CTAC rules that both parties agree to in section 15.1 of the contract, which states, the tribunal should act impartially and fairly. But also, we can look to model law, article 18, which states, the parties shall be treated with equality, and each party shall be given the full opportunity to present his case. To date, the participation of Dr. Mercado is unfair, and Control Systems has justifiable concerns about Mercado's relationship with the professor. And it isn't necessarily that we need to prove that there's a conflict of interest, but rather that our client has reservations about the perception, the appearance of too close of a personal relationship. Dr. Mercado is the godmother of presiding arbitrator's godchild. She also received her job at the university through the help and guidance of the professor, and the 2 have previously served on 3 tribunals in which the professor has never failed to vote for Dr. Mercado's client.
Do you have any ideas of the facts behind those three matters?
No, Your Honor. No, Mr. Arbitrator, we do not have the facts of those three tribunals. But we don't believe the facts of those, whether or not it was actually biased is important, but rather the appearance of the working together in those three previous tribunals lends itself to
Was she a
concerns.
judge or was she a lawyer in those proceedings?
I believe she was a lawyer.
So that you call that working together?
Yes, Mr. Arbitrator, we would.
So was Dr. Mercado on the side of the majority in the decisions or the minority?
It depends. In the first two, the presiding arbitrator was in the majority, they were unanimous decisions, and in the third, Professor Arbitrator was in the dissent. But the fact still remains that never out of the 3 times has the professor failed to vote for Dr. Mercado. But even still, with
Wait, are these votes for Dr. Mercado or for Dr. Mercado's clients? Are there issues and positions?
for Dr. Mercado's clients, excuse me. But even still, if the professional relationship isn't strong enough for the Honorable Tribunal, we can also look to the close personal relationship between Dr. Mercado.
Well, let's not go there yet. Let's talk about any other standards we should use to assess the relationship of this service on prior panels, working together kind of relationship. Is there anything else we should look at other than our inherent powers?
The inherent powers is the ability to disqualify counsel, but I can jump to my second point first, which is why the relationship justifies disqualification in this instance. I'd like to direct the arbitrators to the recent Oecd cases, Hrvatska versus Slovenia, as well as the Rompertrol case, in which the test for what guidelines we apply is you apply the same guidelines that you would use to challenge an arbitrator. So under this case, it would be the IBA guidelines on conflicts of interest.
Which are not binding.
Yes, correct, Your Honor. They are, Mr. Arbitrator, they are not binding, but nevertheless, the parties have agreed to be governed by the IBA guidelines.
They have where?
Nevertheless, even if they haven't specifically agreed to them, you can look to the commentary by scholar Wainsimer, who suggests that the IBA guidelines are they have a lot of credibility and that most parties look to them for guidance. So, under the IBA guidelines, what gives rise to a conflict of interest is whether there's justifiable concerns about whether a reasonably informed third party would reach the conclusion that there was a likelihood the arbitrator may be influenced by facts other than the merits of the case. That's at Part 1, 2C of the IBA guidelines.
Yeah, is this a red case or an orange case or a green case of those guidelines?
I don't believe that they fall into any particular case. Here it is an accumulation of all of the facts together that create the justifiable doubt.
Are you suggesting that taken alone separately, there's not one fact that compels them?
No, Mr. Arbitrator, I believe that independently they're all around the orange waivable conflicts. We're willing to concede that. But the issue is all three, the personal relationships, being the godmother of Mr. Arbitrator's youngest child, but also the relationship at the university, and especially that Dr. Mercado got her job through the facilitation of presiding arbitrator, that combined these three things as a cumulative approach would give justifiable concerns to a reasonable third party. And
so that third party would probably think that I'm not partial, not impartial?
It's hard to speculate precisely what a third party would do, but we can look to...
So don't you have to prove that?
Certainly, but we can look to the scholarship of Professor Wainsimer, who's written about the recent Oecd cases and explains that these are circumstances that would give rise to justifiable concerns, that alone the professional relationship might as well under the orange list, but also and especially the personal relationship and close familial relations would give rise to a justifiable concern. And importantly, I want to make a very critical distinction, which is that it is not the burden of the respondent to prove that there is a bias, but rather that it's reasonable to have concerns, that it is reasonable to assess a familial, a professional, a past three arbitrations would give rise, like that reaction, to whether or not the professor would be considering other facts other than the merits of this case.
You mean to suggest that in the three matters we've had previously, I did consider other facts?
Again, no, Mr. Arbitrator, it's not an accusation of there is definitely being a bias, but rather that there's a justifiable concern and that this tribunal, if you agree with the respondent, have the power to disqualify counsel, which is the issue sort of contended in the briefing, is that this tribunal might not have the power to do so. But we would, I'm running out of time, so I just want to briefly direct you to the authority as to why you may disqualify Dr. Mercado. And the first comes from a letter from the CTAC Secretariat on August 30th, which states, "The tribunal shall be responsible for the procedural issues of the case to resolve disputes effectively and appropriately, and that this is a delegation of discretional procedural authority to do what the tribunal needs to do to preserve the legitimacy of the proceedings."
If they're going to remove me, you have to go to the president of CTAC, would they not?
I'm sorry, could you repeat the question?
If they remove me, you'd have, the person who makes that decision is the head of CTAC.
That is correct, Mr. Arbitrator. However, we here, if we look to this grant of discretionary power combined with the inherent power to gap fill where there's a procedural gap such as there is here, there's no rule that bans the disqualification of counsel. But really what this is an equity issue, is that Elite created this conflict of interest, and they should bear the burden of curing it. And for these reasons, we hope that you would ask Dr. Mercado to no longer participate in the proceedings. Thank you.
First, presiding arbiter, members of the tribunal, good morning. The respondent has asked that Dr. Mercado be removed because there's an inherent conflict of interest with the relationship between the first presiding arbitrator and Dr. Mercado. This relationship actually does not violate the CTAC ethical rules or the IBA guidelines. The relationship is one of professional colleagues, and yes, the professor presiding arbitrator has indeed been on a panel in front of Dr. Mercado as counsel on 3 prior occasions. One of the issues that this presents in the IBA guidelines is one of disclosure, and that is the key elements that are provided under the orange list of the IBA guidelines. The red list of IBA guidelines provides a set of criteria that should exist where a member of a tribunal panel should excuse himself. Under none of these circumstances in the IBA guidelines, however, does it address a member of a counsel's team to be removed. So we would contend, as we did in our briefs, that the respondent is not approaching this from the right direction.
What direction should they move?
Article 30.3 of the CTAC rules clearly state that the appropriate method to address this potential conflict that they see is one to challenge professor presiding arbitrator through the chairman of CTAC. And they must bring this challenge within 15 days of notice of that potential conflict. In this case, they were made fully aware of Dr. Mercado's participation on our legal team clear back in August of last year. And in their brief and in their response to the arbitration here, they simply asked for Dr. Mercado's removal. That is not one of the CTAC rules. That's not one of the available remedies under the rules.
So when you say it's not available, are you telling us that the counsel can misbehave and still during the CTAC proceeding? Can you start throwing water bottles at one of the people who appear before him and not worry about it because there's no express rule?
No, I do believe that the overall guidelines would certainly allow any misbehavior on the part of counsel to be absolutely removed.
Would you regard failure to disclose facts that would lead a reasonable person to believe that there may be something wrong here? Is that it?
If there had been failure to disclose, as there was in the Hardship case that has been quoted, absolutely that would be the case.
If that's the case, if it's absolutely here, it was absolutely in the 3 previous cases too. Has the relationship changed between then and now?
No, if I may continue my answer, I apologize. If there was indeed a conflict of interest, and that conflict had not been disclosed, then there would be reason for some additional disclosure or potentially a question of conflict of interest. The 3 prior cases aren't the issue here. Hardship has been named as the key element, which frankly is not binding on this arbitral panel, but as a key set of facts that applies here. when in fact the facts and circumstances of Havarsky are tremendously different than those here. In the Havarsky case, the counsel was not identified until 11 days prior to the proceedings. And so they continued to keep this relationship hidden. As soon as Dr. Mercado was added as an expert onto our legal team, that notice was immediately given to the respondent. And so that occurred clear back in August of last year. And here we are 6 months later, well beyond 15 days that would be given as a challenge for the respondent to come and challenge Professor Presiding Arbiter.
Do you acknowledge that there are implied powers for us to move counsel?
I do not disagree that the broad powers to address all potential issues surrounding this panel are available to the tribunal.
And so we have, within our discretion, the ability to discharge Dr. Mercado, is that correct?
Most certainly, if there was reason to do so, and if the rules had been followed that allowed such thing to do so. In this case, we're asking for removal, and in fact, we would be happy to stipulate the removal immediately of Dr. Mercado, since that seems to be the sole issue of this conflict of interest, and we would like to remove that conflict and move on to more substantive issues. We will stipulate the removal of Dr. Mercado immediately, since that would seem to satisfy the claim here by respondent that that would then remove the conflict of interest, if they will stipulate that that conflict is indeed removed.
Well, that's the question.
What did the respondent say to that?
If I may have a moment to confer with my co-counsel? Yes, we're happy to, as long as Dr. Mercado is removed, we're happy to not make any challenges under the New York Convention for that issue.
Or under the CTAC rules?
Yes, for this policy, for the relationship between Dr. Mercado and the presiding arbitrator.
Then we will immediately remove Dr. Mercado from the team, and it would seem that that would settle this issue.
All right. Please continue. May I ask a question? Did you offer the stipulation at any prior time to just now in response to questions?
No, we were not clearly apprised of claimant's issue of it was an either-or event, but it seemed to be very apparent here, so it made sense to offer it at this time.
Please continue.
Well, at this time, claimant will be addressing the liability and damages issues.
Before you go on, you accepted the stipulation. Do you have anything you'd like to say in response to it?
Yes, let us just be clear about our position, Honorable Tribunal. We are willing to stipulate that we will not challenge an award under a theory of conflict of interest between Dr. Mercado and yourself. However, we reserve the right to challenge an award under the New York Convention or the CTAC rules for any other issues that may come up in this case.
But not relating to any involvement of Dr. Mercado thus far and the presiding arbitrator, is that correct?
Yes, Mr. Arbitrator.
Is that satisfactory, counsel?
That's very satisfactory to us.
What about my reputation?
We selected you jointly because of your high reputation, and we're completely pleased to have you continue as the presiding officer here.
Thank you.
Mr. President, members of the panel, once again, my name is Brandon Nagy, representing the claimant today, Mediterraneo Elite Conference Services Limited. And I intend to use approximately the next 15 minutes to discuss the issues of breach of contract by respondent and whether or not respondent should be excused from damages resulting from that breach under Article 79 of the CISG. So first, with regards to breach of contract. CISG Article 30 and 33 require that delivery be made at the date specified in the contract. Here, the contract between claimant and respondent specified a November 12th delivery of the master control system with an additional 10 weeks for installation and testing. In fact, what actually happened was that the master control system was not delivered, installed, tested, and otherwise available for use until March 11th, 2010, almost 2 months after the contractual date of obligation. Consequently, this is a breach under the CISG. Now, respondent is arguing that although it breached the contract, it should not be held liable for damages stemming from that breach under Article 79. It claims that the risks that occurred, the impediment that occurred causing its non-performance was so far removed from its control that it should not be found liable.
Did the parties in this case have an agreement for force majeure purposes?
No, nothing in the contract, no term in the contract between Elite and Control Systems specified any allocation of risk other than the default terms of the CISG.
And by default terms, what section are you talking about?
By default terms, I mean the general principles of the CISG, wherein parties take on the role of a guarantor, of an obligator, assuming the risks for their contractual obligations, except in the one limited instance of impediment governed by Article 79.
Okay, that's the precise point of my question. Isn't Article 79 in fact a force majeure agreement?
Well, it's very similar to a force majeure agreement, but
How does it differ?
it's different from force majeure. If you're referring to force majeure specifically as the French doctrine, Article 79 of the CISG is in fact a compromise between common law concepts of impossibility and impracticability with more civil law concepts such as force majeure, excessive onerosa, improvision, and the like. It is something distinct from those doctrines, and under Article 7 of the CISG, which requires the articles within the convention to be interpreted with regards to uniformity and its international character, we argue that concepts of force majeure should not be the interpreting standard, rather the specific text of Article 79 and the interpretations of Article 79. So the impediment requirement that Article 79 discusses, rather than the individual national doctrines.
So Article 79, and we agree that 79 is the closest thing the parties agree to in the nature of a force majeure.
That's correct. Because the contract is governed by the CISG, Article 1 explains that both parties are from contracting states, and since they did not opt out of it in their contract, they are governed. Consequently, the default terms of the CISG, including Article 79, govern this relationship.
Is impossibility find its way into the interpretation of 79?
Well, impossibility has been held to meet the standard of impediment, to be in essence an impediment. However, impossibility is not the sole impediment. Situations short of impossibility have been determined to be impediments, such as situations of hardship, where there would be such an excessive burden on the performing party that it is, as Professor Hunold explained, beyond the limit of sacrifice with which the party should be expected to perform. So not just a reasonable business decision that it would be in their best interest to avoid the responsibility, but rather that it would be so difficult, so compelling not to do it, that even though it was technically possible, it should not be expected of the party.
Was there a technical possibility in this case of overcoming the impediment?
In this case, we submit that there was not. Although the respondent has argued that the fire at High Performance's manufacturing facility was the impediment, we submit that is not the correct way to view this, because in fact the fire spared a number of D28 chips, and despite these chips being available for delivery to specialty devices, High Performance refused delivery. In essence, its business decision was the impediment in this case. And with regards to that impediment under the concept of hardship, we submit that it does not fall under the concept of hardship because in High Performance's letter to specialty devices, it states that it has considered alternative methods, things such as a pro rata distribution for fulfilling its small orders, which would have been specialty devices orders first, but yet ultimately decided it would rather fulfill its regular customers' orders first. This is a business decision, and nowhere in the record does it reflect that High Performance was under such manifest stress, something so unreasonable for it to fulfill specialty devices, admittedly small order, rather than any other course of action.
Can you take us briefly through the requirements of 79.1 and why you think they can't meet it?
Yes, absolutely. So Article 79.1 is what defines impediment. It states that a non-performing party, so in this case, the respondent Control Systems, may be excused from liability if it can demonstrate that an impediment to its non-performance existed, that impediment was the cause of the non-performance, and that the impediment could not reasonably have been controlled, foreseen, avoided, or overcome by the non-performing party. But further, Article 79.2 modifies that requirement by stating that if the non-performing party, so in this case Control Systems, blames its non-performance, that is, says its impediment was caused by a third party, then we must examine whether or not that third party was engaged by the original non-performing party to perform a whole or a part of the contract. So the question is whether or not Control Systems engage Specialty Devices to perform a whole or a part of the contract. Here the facts indicate that occurred. There was a contract between Control Systems and Specialty Devices to design, manufacture, and deliver processing units, a key component of the ultimate master control system that Respondent promised to Elite. Now, with regards to high performance, I know I began talking about them, so it's important to discuss why we're talking about high performance here. High performance is the third party in a contractual relationship with the respondent, with the respondent's supplier, Specialty Devices. Specialty Devices approached High Performance to purchase the D28 chips, a chip that at the time of the purchase order was not yet even in manufacture, and to use those chips for its processing unit. Consequently, that satisfies the obligations of Article 79.2, wherein the non-performing party, in this case Specialty Devices being the non-performing party, engaged a third party, High Performance, to perform a whole or a part of the contract. Now, because Article 79.2 specifies that Control Systems must demonstrate not only itself, but also the third parties it is responsible for, Specialty Devices and High Performance, each meet the elements of Article 79.1, I need to remind the panel that the respondent bears the burden of proof for this defense. They must demonstrate that not only themselves, but each of the parties, Specialty Devices and High Performance, each could not control, reasonably foresee, avoid, or overcome the impediments of non-delivery throughout the supply chain. If the respondent fails at even one of those elements, it cannot be granted excuse under Article 79. So with specific regards to some of those elements, our brief explains why we believe respondent fails at multiple, but in the interest of time, I will just use a few as an example. With regards to control, respondent has claimed that itself, Control Systems, did not have any control over High Performance. Yet we argue that scholarship and cases such as the Vinewax case, the Paprika case, the metallic sodium case, and the many others cited in our brief all come to the same conclusion. A seller bears the risk of acquisition of the goods it is selling. That is to say, it bears the risk of defaults in its supply chain, that its supply chain will be unable to. This is because the seller chooses its supply chain. It chooses which parties to contract with in order to help it fulfill its obligations.
Did it have a choice in this case? Wasn't the contract offered? Performance would have only occurred one way. This was the D28 chip.
Actually, the original contract between claimant and respondent did not specify for the D28 chip specifically. The contract included an annex, Annex 1 in the record, which had merely performance specifications. See, claimant, we are in the business of conference services, of hosting conferences and events. We have no idea about the technical specifications or how electronic components are assembled. That is why in our contract, we hired respondent to design, manufacture, and produce the master control system. And we deferred to their expertise to acquire the parts necessary. Our only say was the items that we needed, the particular functionalities that we needed. But nothing in the record indicates that the D28 chip was the sole chip that could have been used to meet these specifications. Perhaps an array of other less new chips could have done it. We don't know, and the respondent has not alleged that any other method would be infeasible. Consequently, they cannot meet their burden of showing that they had no control because the D28 chip was the only potential chip, and thus their supply chain was chosen for.
Excuse me, if the D28 chip was the only, if they proved that the D28 chip was the only one that would satisfy the contract, what would be your position?
If the respondent was able to convince the tribunal that the D28 chip was the only chip able to satisfy the contract, despite the fact that it was not yet even on the market or had been manufactured or tested before at the time of the contract conclusion, I would still argue that that may demonstrate control systems and specialty devices did not have control over their ultimate choice of supplier high performance. Yet because control systems is still responsible under Article 79.2 for high performance, we must still examine whether or not high performance had control over this impediment. And as claimant, we argue that they did not. And the reason high performance did not have,
The impediment being,
or pardon me, excuse me?
the impediment being what?
So we argue that high performance's impediment was its business decision to repudiate its contract with specialty devices. That is, to intentionally choose not to deliver the chips to specialty devices, despite the fact that in its warehouse it admittedly had ample supply, enough chips to satisfy the order, but instead chose a different result for business reasons.
Was that foreseeable?
We believe it was foreseeable for the parties. Specifically, specialty devices was relying on a chip that had never been manufactured before. The manufacturing process was not proven. While the particular fire may not have been foreseeable, in general, delays in manufacture, especially with regards to a new product that had never been built before, are foreseeable. The fire was just one manifestation, one possible type of delay. And specialty devices could have foreseen that there would have been a delay in acquiring this new chip, and therefore
So
it would have
that
affected
the
its...
delay would include the cronyism factor, the fact that they sold a lot of chips to an old friend?
Well, cronyism itself may be problematic here, but even if that was the cause, again, it is just a symptom of one of many potential delays. And the fact remains that chips were available, and specifically with regards to, this will transition into the concepts of avoidance or overcome for specialty devices. Specialty devices, or control systems itself, respondent is claiming that specialty devices could not have overcome the impediment because it approached Atlantis Technical Solutions, the ultimate beneficiary, the cronyism as the tribunal has said, to purchase the chips and was rebuked. But the record does not reflect that prior to the delivery of those chips, specialty devices ever approached or attempted to negotiate further or express that its priority, that it needs these chips desperately and it's only a few chips. It never approached high performance to determine whether or not it should receive priority. Instead, it meekly accepted a letter and a phone call stating that high performance believed it would be the better business decision, the justification that high performance gave. And furthermore, if cronyism, as the tribunal has put it, was the real decision, we submit that does not meet the Article 79.1 concepts of hardship, specifically because economic hardship requires the burden to be beyond bear. The burden that the respondent has is showing not that there was some sort of cronyism affecting the distribution, but that it would have been a manifestly unreasonable business decision to deliver just a small order of chips to specialty devices, instead of delivering all of the chips to Atlantis Technical Solutions. Because control systems, the respondent bears the burden of proving not only itself, but also specialty devices and high performance each meet the requirements of Article 79.1. And because it cannot demonstrate that all elements are met, that none of those parties could have reasonably controlled, foreseen, avoided, or overcome their various impediments to delivery, we submit that the respondent should not be excused under Article 79.1 and should be held liable for the damages caused by its breach of contract. Thank you.
Go right ahead.
Honorable Tribunal, I will be discussing two issues of liability. First is I will be discussing liability in terms of whether there was even a breach. And to assess whether or not there is a breach, I would like to direct the tribunal to Articles 25 and 29. And secondly, in the alternative, I will be discussing where if this tribunal were to find that our client breached the contract, then they are still nevertheless exempt under Article 79. So first, our client did not breach the contract for two principal reasons. The first is you can look to Article 25, which states that a breach of contract has been committed unless the party in breach did not foresee and a reasonable person of the same kind in the same circumstances would not have foreseen such a result. We can look to Scholars Bourne and Scholars Schwenzer for what exactly this means. What does it mean to be foreseeable? What does it mean to be a reasonable person? These scholars have concluded that we look to the knowledge of the client at the time of contract.
Why don't you tell us what you understand the evidence in that subject to be?
Yes, Mr. Arbitrator. At the time of the contract, my client only knew what was provided in Annex 1, that Elite wanted the highest performing control system that we could produce.
Do you
There was-
agree that the D28 fit that bill?
According to Procedural Order 2, the only chips on the market that could fulfill the specifications were the D28 chip, and that's Procedural Order at paragraph 5. But importantly, at the time of the contract, there was no scheduled event, which means that pursuant to the CISG, I believe Article 47, it's 47, you can ask for a reasonable extra time if there's no impending damages. So at the time of the contract, our client, there was no upcoming event, we were just going to produce the best possible control system that we could. But secondly, there's no breach under Article 29, which governs post-modification. There was a post-modification of the contract beginning on September 10th and also on September 13th.
Doesn't that require an offer?
Yes, I will read the specifications for Article 29. Provides, 1, a contract may be modified or terminated by the mere agreement of the parties, especially, and number 2 goes on to say, especially if the party has relied on the conduct of the other party. In this instance, my client relied on the conduct of Elite during the month of September. I would also like to point us to...
How did they do that? How did they rely?
Yes, so in 2 important ways. But first I want to address this to Scholar Diamateo, which tells us what it means to rely, right? How do we determine whether or not there's acceptance of the offer? Which says the agreement can occur orally, in writing, by acts, or even by silence or inaction. And here, that has occurred in all 3 ways. First, on September 10th, there was a conversation between my client and Elite that there had been a fire, and then on September 13th, there was a written communication to confirm the contents of the September 10th communications, and offering to perform at a later time by mid-January. And this is consistent with commentary that's been offered by Scholar Swengler, who explains that contract modifications typically take place in reaction to changes in factual circumstances. That is precisely what happened here. Here, there was 2 substantial changes in factual circumstances. 1, there was an upcoming conference which would produce damages, but 2, that there had been a fire at the manufacturer. And finally, you can look to Elite accepted this offer. We can refer to the previously quoted Scholar Diamateo about orally in writing, but also by silence or in action. And the threshold is simple for Elite. They only needed to express dissatisfaction with this delay. It could have happened on the phone, by email, by text message. Their only burden was in the month of September, immediately after receiving a correspondence from my client, to express, no, this isn't going to work for us. We have an upcoming conference. It's going to create a lot of damages for us. That failure to communicate is an acceptance of a post-modification of the contract.
Did any of these conversations in September or communications from your side to them talk about the likely date of performance?
Yes, it's specified mid-January, which is precisely when they performed. I would also like to direct the tribunal's attention to Procedural Order 2 at paragraph 16, and also the statement of facts at 12 and 16. The original contract, my client was going to provide the installation and configurations within 10 weeks, but my client has done above and beyond that because they actually performed it only 8 weeks. Our client has proceeded in a reasonable, good faith practice to provide the client what they asked for at the time of contract and to accommodate changes in factual circumstances by post-modifying the contract. Even still, in the alternative, if you believe that my client has breached the contract, they are exempt under Article 79. I would like to make one very important clarification under the 79 analysis. If I can direct you to 79.2, it reads, this is addressing the question of who must meet the test under Article 79. It's a third person whom he has engaged. Whom he has engaged. Our client did not engage high performance. and high performance is therefore does not need to meet the test of Article 79.
So you can escape all liability by creating a straw man transaction, let's say. If I was a lawyer advising clients down the road, under what you just said, I could escape liability by simply sticking somebody between me and somebody else. Is that your position?
Not quite, Mr. Arbitrator. I think it's much more reasonable than that, which is we contracted with Control Systems and we are willing to be accountable for the decisions made by our subcontractor, but otherwise the road is endless. Where do we cut this off? The supplier, and then who provided the machines for the supplier? Like, we have to draw a line somewhere. And we contend that the CISG reasonably draws a line at whom you have engaged, whom you've made a decision to deal with.
What authority do you have for that it doesn't look through the relationship? You have a direct relationship with another party down the supply chain.
Mr. Arbitrator, we would like to just refer to the precise text of the CISG, which provides that it is only applicable to subcontractors or to third parties with whom the party has engaged. And our client has not engaged high performance. But now let's look to what our client must satisfy in order to be exempt under Article 79.
What is the standard of proof required?
The claimant is correct. We do have the burden of proof for exemption under Article 79. However, the claimant has the burden of proof for proving there was a breach, as was addressed in my earlier point. So here, for Article 79, first, our client, the fire was beyond the respondent's control. The claimant has asserted that the fire was not the impediment, but if you look to the other requirement, is that the fire was the sole reason for non-performance. But for the fire, our client would have performed in a timely manner. So it is properly defined as the impediment. But moreover, so really what the claimant is getting at are two issues of foreseeability and our failure to overcome. So let me address those two in order. First, our client could not have foreseen the impediment. I would again direct you to Magnus and Slectrium, who described that the test for foreseeability, as applied in Article 21, is what our client knew at the time of contract. And again, at the time of contract, what was foreseeable was that they wanted the best possible chip. There was no impending conference, which means that it is not reasonable for us to have included a provision in our contract to account for a possible fire, because there was no urgency, and we had the option under Article 47 to extend the deadline if needed and if reasonable, which is what would have happened if there wasn't an impending conference.
Counsel, what good faith due diligence did your clients undertake to see that this chip was available, number one, and number two, was being secured in a manner that would provide the highest level of care?
Yes. So preliminarily, fires at chip manufacturers are extremely rare. As an esteemed colleague who has sat on tribunals at this competition, Mr. Wickwire, has stated, they're dust-free environments, there aren't papers lying around, so the chance of fire was 0 to none. But even still, because there was no upcoming conference, they had the option under Article 47 to extend a deadline if a fire were to occur. So where the circumstances changed materially is on August 5th, when after the time of contract, that the claimant notified us of this upcoming conference. But I think even still, as I'm running out of time, I want to get to overcoming, which I think will also address your question, Mr. Arbitrator, is that our client tried to overcome. We sought out Atlantis, who received the distribution of chips, to ask them if we could purchase the chips from them. But they declined, and they had no reason to provide them for us. And so all in all, our client has proceeded on good faith. We performed in 8 weeks instead of 10. We did not breach this contract. There was a post-modification. And for these reasons, we hope that you'll find the respondent not liable for damages.
What was the cause of the fire?
The cause of the fire was ruled to be an accident at Procedural Order 2, Paragraph 8.
If I may briefly rebut. There are 2 points I would like to address. The first is with regards to the D28 chip. Specifically, respondent has just claimed that under Procedural Order number 5, the D28 chip was the only chip necessary. If I may direct the tribunal's attention to that paragraph, it actually states that the D28 chip was not specified in Annex 1, period. That's it. There's no more to that order. The fact of the matter is that Elite had no idea what chips would be used, and did not even know the D-28 existed or was a problem until September 13, when it was notified by Control Systems that the chip would no longer be available and therefore would cause a delay in the performance. And with regards to my second point, modification, respondent is arguing that somehow Elite manifested assent to an agreement to modify, but yet the facts on the record do not support this. Article 29, as respondent astutely pointed out, requires agreement of the parties. Article 18.1 defines what agreements mean, and says specifically that silence is not agreement unless there are other factors, perhaps such as continued performance and reliance. However, the facts here do not indicate any of those other factors. Specifically, respondent has cited that because they were still paid for delivery and because the technicians still allowed them access to the MSVs, that was an acknowledgement of an agreement to modify the contract. However, all of those actions were part of the original contract in a non-modified form. Those actions are consistent with the original obligations of Elite and not some modified form based on a late delivery. Furthermore, payment was secured by a letter of credit, something that claimant Elite had no control over once the contract had begun. Consequently, the inferences should not be made from those facts of a modification, and the tribunal should determine a breach, and that respondent is liable for damages stemming from its breach. Thank you.
We'd now like to, with the tribunal's permission, address the issue of damages. Article 45 permits a claim of damages for the full amount when a seller fails to perform any of its obligations. Article 74 provides that those damages need to be foreseeable. And Article 77, that those damages need to be mitigated by the damaged party. Here it's very clear that there was a breach. It's very clear, as the respondent just testified, that the delay in the delivery would indeed provide a set of damages. The damages that were indeed foreseeable at the time of contract. Let's back up in time just a little bit. We contracted back in May. The respondent has argued that they had no idea that there was possibility of a future excursion or lease of this yacht that they were in the process of refitting. Elite Conference Services is in the business of conference services. It is completely foreseeable that this new venue, the MSVs, would absolutely be used at some time shortly after the contract deadlines to host conferences. So at the time of contracting, we argue that indeed it is foreseeable that there would be, if a delay occurred, an absolute damage breach. And we did have that. When we were informed that the breach was occurring and that the delay would indeed be to sometime in January, we already had a February conference scheduled. That February conference absolutely had to go on. We looked first to mitigate those damages as are required under Article 77 to the least cost possible. We have 6 land-based venues that are wonderful, and each of those was offered up to Worldwide Executive. They refused any of the land-based opportunities and said, no, you know what, you contracted for the MSVs. We really have counted on a water-based venue. With great diligence and search, we secured the MS Pacifica. The cost of the MS Pacifica was $448,000. Not unreasonable relative to the cost of a super yacht. We also had contracted for a $60,600 or 15% of
What
the
is a super yacht?
I'm sorry?
What is a super yacht?
A super yacht is actually a class of yachts of which there are very few in the world, and you have to consider that this yacht has, the average super yacht has a cost in excess of $300 million. These don't just sit around in the harbor on a regular basis. $448,000 for the rental fee of this yacht, very reasonable, given the urgency and the fact that by the time the broker was able to find and identify, it was identified that there was only this particular yacht that was available for this particular time that would satisfy the needs and the contractual obligations that Elite had made to worldwide conferences.
Did it do that?
And we did indeed make that contract.
And did you satisfy him?
When we finished, we actually had a partially satisfied client. They identified in the record that the client was okay with, or satisfied with the result. We're not in the business of satisfying at Elite Conference Services. As the name stipulates, as the name identifies, we are elite conference services. We're not average conference services. A super yacht is a very special class of yacht. The MSVs was identified, and respondent's client was in absolute terms to provide a very high-end, state-of-the-art technology that made the MSVs a very unique finished product. The Pacifica was not that finished product.
At what point in time did you notify the respondent of this decision to secure an alternative and what the approximate cost was going to be?
Articles 74 and 77 actually don't require us to do that. We actually work diligently to secure that yacht at the lowest cost possible, and that's what those articles require. So we did not have that communication.
So that means at no time prior to the event did your client have any communication with the respondent about its intent to secure an alternate vessel?
No, based on the communication that we had received from respondent, that there was no possible way for them to deliver the yacht in time for this event, with a starting delivery date on January 10th. I'm sorry, mid-January, pardon me, we weren't given a specific date. That there was no time for the configuration to occur prior to the yacht being needed for our event. And so we mitigated the damages in the lowest cost possible way by securing this alternative, the MS Pacifica.
Let's talk about the other elements of damage.
Certainly. There's a $60,000 success fee that was paid to the broker. It has been, I'm sorry, a $50,000 success fee that was paid to the broker by our client. That broker then used that fee and paid a bribe. The record clearly states that the bribe was paid in Pacifica. The record also clearly states that our client had absolutely no record, no knowledge of the circumstance surrounding this bribe until after that had occurred.
Was this paid in addition to a commission?
This was paid in addition to the commission.
And why was that?
As I had stated earlier, the singular yacht that was possibly available was the MS Pacifica. If we had not been able to secure the MS Pacifica, the record also clearly states if we had repudiated the contract or been unable to fulfill our contract with worldwide executives, we would then have not been able, then the damages would have been much greater than what we're dealing with here today.
So I'm going to pay you a commission and then I'm going to pay you more. Is that essentially what happened?
We paid the broker more in order to gain certainty that we would indeed have that yacht. There are commissions regularly paid for all types of transactions. This transaction is slightly different in that there was a very specific time and a singular vessel that was possibly available. The concept of an additional commission in order to secure this very unique item is completely reasonable in looking at the circumstances that surround
So
it.
you said, you used reasonable a lot. You said
Sure.
the commission was market commission.
Absolutely.
What's the success fee, market success fee plus commission?
Actually, the record does state in the procedural order number 2 that success fees are occasionally paid, and this is certainly a circumstance where, based on the uniqueness of the transaction needing to occur on a certain date with a singular possibility, that certainly would fit into the available and reasonableness of an occasion.
Are we bound to accept the decision by the Pacifica Court that a bribe occurred?
The Pacifica Court does not rule here. Our contract is under the rules of Mediterranean. We have absolutely, Danubia. We have absolutely no relationship in a legal sense with the boards or holdings of any proceedings in Pacifica. And even if
And in fact, the whole purpose of going to Pacifica was to get the boat. They got the boat, the yacht. You can't say that you had no involvement in Pacifica. You sent money to be used in Pacifica. Money was used in Pacifica. It was used improperly. And now you want to charge the respondent for it.
it was used properly when it left our bank account in order to compensate the broker for a guarantee of securing this yacht.
No matter how we did it.
That became an issue that he addressed, and there were responsible parties that were convicted in Pacifica for that. That is not a responsibility of Elite.
Are you suggesting that a general concept against bribery is not a part of the international well-accepted law that would otherwise exclude us from considering it and ruling on this?
No, I think it is an absolute accepted principle of law. However, it doesn't apply here because the elite had no knowledge of it and wasn't a party to that. In conclusion, $112,000 partial refund, which I know the committee, the tribunal would like to address. This was paid in order, as I said earlier, the Pacifica was an alternative. It was an okay situation. But this was not the MS Vis. This was not the opportunity to present the world-class, first-time used conference technology. This was a reasonable, possible, okay alternative.
And it was reasonable for you to expend these sums, right?
Absolutely.
And having done that, it's reasonable for you to come in and ask the respondent to pay for them.
Well, as a matter of fact, when we began these proceedings, we asked the respondent simply to cover half of these costs, as is shown in the record. In future,
would that be an unprivileged or privileged sudden communication?
no, that's not privileged. We asked for the respondent to pay a portion of those costs, and I see that my time is out. Let me conclude by saying the $112,000 was indeed a necessary and needed cost. Had we forgone the goodwill and the future business of this client, the damages would be substantially greater. They are measurable in that it is a small portion relative to the client relationship that exists. And if we had damaged the client relationship, again, those costs would be substantially greater as supported by the record. Thank you very much.
Good afternoon. May it please this honorable tribunal, my name is Andy Murphy and I represent the respondent in this matter. Granting a lease request would damage the integrity of these proceedings. That is because the lease would run counter to international public policy because it was obtained via an illegal bribe. Furthermore, the success fee is neither reasonable nor foreseeable because it was used for illegal purposes. And third, the ex gratia payment is neither reasonable nor foreseeable because it is a purely speculative matter for non-pecuniary damages. First, as to the matter of violation of international public policy. The tribunal should not award damages related to the lease because doing so would violate international public policy. To make a decision in concord with international public policy, the tribunal should apply Pacifica law, and under that law, the lease is void and an invalid source of damages. The claimant's
different results here if the party receiving the bribe was an official of the state country of Pacifica.
Pardon me?
Is there a different result when you have a public person being bribed versus a private bribe?
No, presiding arbitrator. Both are violations of international public policy. And we can look to the OECD Convention to identify that. The OECD Convention is an international document signed by every enforcing nation to this proceeding and the seat. And the OECD Convention imposes clear duties onto enterprises to avoid furthering international corruption via illegal bribes.
But isn't it focused on payments to government officials? As opposed to, for example, the new UK anti-bribery statute, which deals with private parties.
Yes, Mr. Arbitrator, its primary focus is on public officials. However, Section 7 imposes guidelines that restrict enterprises in pursuing bribery. And the bribery of private officials has the same evils as public officials, and the convention names them. They are named, it is damaging to international commercial businesses because it damages the governance of corporations, distorts international competitive conditions, and disrupts economic, social, and environmental welfare. And while that is certainly present in bribing public officials, those same evils are present in bribing private officials.
And one of the problems we have as a panel is that we don't have the ability to send people to jail. We don't have the ability to find them guilty of crimes. We don't have the ability to put them on probation. All we can do is give money. My question to you is, what significance do you attribute to the idea that they want you to pay for the bribe?
It is our contention that that is a violation of international public policy which should not stand. This tribunal need not evaluate any claims of guilt, for the competent courts of Pacifica have already done that. And as Scholar Kreindler notes, arbitrators are duty-bound to apply laws that uphold international public policy. As Redfern and Hunter note, contracts obtained through bribery violate international public policy.
Can something that's a crime also be a basis for civil recovery? Suppose you're walking down the street and I come and hit you in the head, take your wallet, and you've got $50 in there. Don't we have the ability to assess the $50 liability?
In that situation, yes, Mr. Arbitrator, because the person who would be seeking damages would have not partaken in any illegality. I would direct the tribunal's attention to the World Duty Free case, which I think will help draw that distinction. In that case, the claimant contracted with the President of Kenya to provide duty-free shops and update some facilities in an airport. To obtain that contract, the claimant paid a $500,000 US American dollar bribe to the President. Subsequent to that, the President of Kenya frustrated the claimant's attempts to perform that contract. The claimant brought the case before a tribunal, and that tribunal found that the venue of international arbitration was foreclosed to him because he obtained the contract through bribery. As soon as damages have a nexus to being obtained through a bribe, the tribunal should not award any damages whatsoever connected to that.
Okay, what damages do you contend in this case apply to that?
That would be the $448,000 rental fee for the Pacifica Star, and the $60,600 broker fee, which the broker was paid to make the bribe. I think there are some helpful elements in the OECD Convention which demonstrate how the good faith and perhaps ignorance of the bribe do not absolve elite from the bribe. Specifically, we can look.
Doesn't the government somebody who made the bribe as opposed to somebody who funded the bribe inadvertently?
No, Mr. Arbitrator. Specifically, Section 7, Part 4 of the OECD Convention imposes a duty on companies to maintain appropriate and regular oversight of agents and remuneration and that remuneration of those agents is appropriate and for legitimate services only. This would include some sort of institutional oversight to make sure that the broker wasn't going to do anything illegal with the funds that were provided to him.
This is all for government stuff. I mean, the OECD Convention was passed to deal with bakshish in the Arab countries, where there's an agent that shows up and you have to pay these people to get access to certain decisions. I mean, isn't that right, or do you think this should apply to the civil context this severely and this heavily?
I think they are certainly, yes, I do think they should apply to the civil context because they are informative. I would also rely on the World Duty Free case, wherein they found that the bribe to the President of Kenya was common within that culture and nonetheless offensive to international public policy and therefore foreclosed any damages related to it. So we're going back to Section 7, Part 4. It imposed a duty on the company to make sure that their funds were not being used for any illegal purposes. We can also see this duty in Section 7, Part 3, which says, and I quote, companies should prohibit or discourage in internal controls, ethics and compliance programs or measures the use of small facilitation payments which are generally illegal in the countries within the place of performance. This is precisely what the OECD Convention was talking about. This was, if nothing else, a facilitation payment that was illegal in Pacifica, and therefore the elite failed to meet that duty and standard to maintain the integrity of international commerce, and they should not be rewarded for their negligence. Consequently, if we're not applying Mediterranean law because where it violates international public policy related to the bribe, this tribunal should apply Pacifica law, specifically to the lease of the MS Pacifica Star. That's because, as Scholar Kreindler notes, when a tribunal doesn't apply the party-chosen law, it should apply the law of the place of performance. In this case, that's Pacifica. It should also apply it for a second reason. Article 1453 of the Pacific Criminal Code is a comprehensive ban on international bribery. It criminalizes the person who offers the bribe, and it makes it a crime to accept the bribe.
But why would we apply the law that's set forth in the contract?
Because it violates international public policy. And the tribunal...
Applying the law that applies to this proceeding violates international public policy. Why are you asking us to change that?
We are asking the tribunal to not apply Mediterranean law specifically to the lease, and it is empowered to do so through the doctrine of loi de police, as scholars Kreindler and Park note, that where the party chosen law violates international public policy, which the OECD Convention would illustrate, that the international public policy trumps the choice of law. Those are the direct words of scholar Kreindler. So I'm suggesting that this tribunal should rely on the doctrine of loi de police to invalidate Mediterranean law and instead apply Pacifica law. In doing so, the tribunal will conclude that the lease is a void and an invalid source of damages, as the conviction of the assistant demonstrates.
Okay, so let's take all that out of it. Now let's talk about the quantum of damages themselves. If the panel were to, at least for purposes of argument, reject the argument about bribery. So what are you saying about the $448,000 number? Is that an unreasonable amount? Is it a foreseeable amount?
We would rest our argument on the lack of foreseeability. That pursuant to Article 74, the lease must have been foreseeable at the time of contracting. The contract was signed on May 26th, and our control systems was not made aware of the conference until August 5th. Therefore, it could not have been foreseeable at the time of contracting.
Wouldn't they think they should put it in and drive around the harbor?
Well, Mr. Arbitrator, as Scholar Zeller notes, that when there is an unusually high cost of breach or failure to delivery, that it imposes a duty upon the party seeking those damages to educate the other party at the time of contracting. To interpret Scholar Zeller's words, that would have placed a duty on Elite to inform control systems that had the post-modified contract not been performed, that there would be a significant amount of damages incurred.
But you knew it was a yacht, not just a yacht, a super yacht, right?
There's no indication that the record says it was, that our client knew it was a super yacht. The contract merely says that it was for the MS bid. It doesn't necessarily reflect the quality of that.
But your client's in the business of outfitting these vessels, right?
We're in the business of providing control systems, not necessarily unique to large yachts.
And the fact that they were asking for the most unique, newest, hottest, coolest control system, the D-28 ship, it wouldn't have tipped you off.
We would, in that situation, rely on Article 47 of the CISG, as my esteemed co-counsel mentioned, that without knowing that there would be an immediate event that would be planned not 2 weeks after the scheduled performance, that we would have had the opportunity to extend the deadline of performance. So aside from the bribery argument, it is our contention that the lease for the MS Pacifica Star is not a foreseeable damage. The same is true for the success fee, which is neither reasonable nor foreseeable because it was used for illegal purposes.
Well, let's take the illegal purposes out, and let's just talk about the success fee, let's talk about the broker fee and then the success fee as a matter of market or reasonableness. So is it your position that 15% fee is not reasonable in the market for broker services?
No, Mr. Arbitrator. Should this tribunal find that the lease was obtained legally, then the brokerage fee would be a reasonable amount to obtain a subsequent yacht. However, it is our contention that the lease was obtained illegally, and therefore that damage is inappropriate to be awarded.
And what about the success fee?
The success fee is not reasonable, aside from the fact that matters of illegality are generally unreasonable and generally unforeseeable. It's not reasonable to be paid twice, as Mr. Arbitrator identified. The yacht broker was already paid a generous sum of 15%, $60,000, and people are generally paid once for the work that they do. To that extent, it would be an unreasonable amount to compensate the yacht broker over a fourth of the value of the yacht. Additionally, we can look to procedural order number 2, paragraph 23, to see that success fees in general are not customary. To suggest that it's not customary is to suggest it's not a reasonable fee.
Or that it's not foreseeable?
We would suggest that it's not foreseeable, correct, thank you. It's further unreasonable for the argument that I raised earlier, that Elite failed to educate control systems about the unusually high costs of breach and failure to perform. And as Scholar Zeller noted, failure to make that education equates to a forfeiture of those damages. Due to a lack of education for control systems as to the high costs of breach when the contract was formed, May 26th, any damages that we were made aware of after that date were not of our knowledge and therefore not foreseeable. Additionally, I would also re-emphasize that the double payment is not foreseeable generally. As for the extra payment, it is not reasonable because it's purely speculative. The elite unilaterally decided that $112,000 would be an appropriate ex gratia payment, and we have no way to verify that that compensation for a non-pecuniary loss is reasonable. In situations, Mr. Arbitrator?
They accepted it.
Pardon?
It was satisfactory to their customer.
It was, which brings me to another reason why it's not foreseeable. It's not foreseeable to compensate for a successful conference. And as Respondent Exhibit 1 illustrates, this was a successful conference that was enjoyed by its attendants. It's not foreseeable to give a refund for a successful event. But back to the issues of why it's not reasonable. In the extra object payment specifically, in situations where courts and tribunals have awarded non-pecuniary damages, it's because the party seeking them provided specific reasoned evidence why the damages claimed represent concrete damages caused by the breach. In the Cheese case, some of those factors included records of past profits, profits from similar businesses, or expert evidence of the trade. None of those factors have been presented here, and lacking a concrete way to identify damages and remove this $112,000 from pure speculation, this tribunal has no way to determine if those damages are reasonable. Additionally, it's not foreseeable, the extra object payment was not foreseeable for what I've already argued, that we were not aware of a conference when we signed the contract, and Article 74 would foreclose any damages we were not aware of. Additionally, it is a violation of the Article 77 duty to mitigate damages to voluntarily inflate the cost of harm with the expectation that control systems would pay it. They weren't asked to provide this payment, they volunteered it, and they volunteered it in an extraordinary sum. That's the opposite of mitigation. To conclude, elite should not be granted their request for damages because there is no breach under Article 25 of the CISG, a post-modified contract that was performed early under Article 29. Further, they are exempt from any breach under Article 79, and the damages for the lease should be not considered, for they violate international public policy, and neither the success fee nor the ex gratia payment were reasonable nor foreseeable. Thank you.
My time has expired, but if I may have a minute to reply, I'd appreciate it. Thank you. With all due respect to our esteemed colleagues on the other side here, I would like to set the record straight on a number of small points that actually have substantial impact. They suggested that the 8-week delivery after January 11th was an acceptable delay. The contract didn't call for 10 weeks after November 10th. The contract called for a completion date on November 10th. In addition, the broker for the yacht was not our agent, and the record clearly states that he wasn't our agent. As our colleague has correctly identified, the OECD identifies that for agents, there is liability for the principal. That's not the relationship we have here. This was not a public bribe, and our client was in no way aware of it and had no knowledge of it. In light of these elements, we do ask that the tribunal fine for our client the full sum of the damage of $670,600. Thank you very much.
Concluded. We will now exit ourselves and do what we're supposed to do, which is make a decision. I'm going to tell you, it's going to be tough. Good job.
Thank you.